Thank you very much, sir, for accepting our invitation. We welcome you for this webinar, and over to you, sir.
Thank you. So friends, I'm happy to interact with all of you from Bombay on this virtual environment. I'm sure that day before yesterday, you had a lot of difficulties, but hopefully things would have improved. And you should thank the cyclone also for having bypassed Bombay and not creating too much of damage. Okay. Yeah. Now, the object of this program, this particular session is to discuss certain aspects about cyber crimes, because I understand that you already had several sessions on cyber law in general. So several aspects of Information Technology Act could have been discussed. So what I have tried to do is to actually provide a sort of an overview of the Act, of course, but from the perspective of mapping cyber crimes to the provisions of Information Technology Act. And simultaneously, you can never discuss cyber crimes without discussing cyber evidence or digital evidence, which has got a lot of techno-legal issues. So I'm going to discuss substantially on digital evidence, because as engineering students, your interaction with the cybercrime area would be more on forensics and digital evidence. Of course, forensics I'm not discussing in detail in this particular session, but I will talk about the legal aspects of digital evidence. I will pick up some cases for discussion just to give you examples of how a technical person has to look at a cyber crime situation. Now, when we want to prove a cyber crime in a court, there will be a requirement for identifying a specific section in an appropriate act. For you have heard of things like FIR, charge sheet, and other things. So if somebody has to say that so-and-so has committed a cyber crime in the FIR, which is the first information report, they have to indicate the section under which the offense is supposed to have been committed based on the preliminary investigation of the investigating officer. Then by the time it becomes a charge sheet, this investigating officer should have actually conducted a lot of further deeper investigation, come up with appropriate evidences, and this should normally happen within 90 days of the filing of the FIR. So between this time, there will be a lot of technical issues which the police will have to sort out, and normally they will be having the technical assistants within the organization, within the police, and they will have public prosecutors to consult which section has to be applied for. There are many cyber crime divisions of police who also associate themselves with engineering institutions so that they can take the guidance whenever it is necessary. Though at this point of time, there are a number of cyber labs which have been set up by different cybercrime units, including your Bandra unit or something like that, where NASSCOM in association with DSCI has set up certain equipments so that the police can be trained and they can also perhaps use it for investigation. But whatever police do as forensics for investigation is only for them to prepare the initial investigative framework. But for production of the evidence in a court of law, the evidence gathered by the police themselves will not be useful. There has to be an external agency like the CFSL, the Forensic Science Laboratories, which have been set up by many state governments and central government. So police will have some investigative capabilities within the department, but they will have to use it only for investigation purpose. While presenting it in the court, they will have to present evidence which will stand in a court of law, for which an independent forensic lab may be required. And there are many instances where the litigants would be seeking the assistance of private forensic labs and private experts, because they also need to be in the loop for bringing out truth in cybercrime cases. For this purpose, that is for identifying which section of an Information Technology Act is applicable, one has to understand the modus operandi of a crime in technical terms first, and then convert each steps in these technical terms and map it to different sections of the legislation and say this particular incident has a relation to section 66, 67, 68 or whatever is there in the Information Technology Act. So for this understanding of the modus operandi of the technical aspects of crime is important. That is where the engineering brained people will be of use. Now, after this, there will be a need for collecting appropriate evidence, and sometimes evidence will be collected today and the court case will come after 6 months, 1 year. So keeping the evidence in safe custody, presenting it in the court at the appropriate time, and the other party will definitely challenge it, so defending it. These are also part of proving a cyber crime in a court. This is part of the cyber forensic activities. Now, this cyber forensic activity also extends to identifying the person who could have committed the offense, and also quantify the damage caused to the victims, and also gather what we can call as objects of commission of the offense. Whatever are the electronic documents which are evidences, which you can call as this is the object of crime. So those are the things which come under cyber forensics. As I told you, on technical aspects of cyber forensics, I am not dealing today. I am only talking of legal aspects of cyber forensics as well as digital evidence. Now, before we go further, we should first have a clear understanding of what we mean by cyber crimes. By definition, what is cyber crime? So, one way people have earlier in the olden days defined cyber crime is, it is an offense under law where computer is a tool or target of crime. So this is actually the FBI definition where they linked the cyber crimes to a computer. Either the computer should be the target of a offense or it should be the tool of offense. And the offense is related to the existence of a certain law. Unless a law says that doing this is an offense, it doesn't become an offense, it doesn't become a cyber crime. So whenever a computer is affected, it was considered as a cyber crime. Now we in India adopted a slightly modified approach, which I have been highlighting ever since I started teaching cyber laws since around 2000. We look at not the inanimate object called computer or data. We look at how an offense adversely affects an individual. See, ultimately, law is there to protect the individuals who are citizens of a country. And the citizen of a country, his rights may be affected because of the use of a computer. Therefore, cybercrime is not something which damages only a computer. It has to damage an owner of the computer. Of course, if my computer is damaged, I am losing the computer. To that extent, this 10,000, 20,000, 30,000 is a loss. So every damage to a computer does constitute a damage to the person who owns that computer. But there is a degree of difference between damaging a computer as a hardware and damaging information residing inside the computer, which creates its own damage. For example, if you look at a very recent incident when one of the big companies in India, say I am looking at this as a virtual educational environment, so I will be speaking about the names of all published cyber crimes. So please understand that within an educational environment, there is no bar on quoting cases. Okay, so we had this recent incident where Cognizant was affected by a ransomware. Now, what is this ransomware? It was a malware which came into the network and it encrypted all the data there. Now, was any computer damaged? Now, the question is what we consider as computer. If you consider computer as a hardware, no hardware was perhaps damaged, but the information residing inside the computer was affected. Even that was not deleted. See, when it is encrypted and the person says that I have not done anything to your this thing, I have kept it in safe custody, if you want to get the key to open it, you have to pay me some ransom. That's all he's saying. So now the question is, what is the degree of this crime? Should we look at this crime like somebody else who has damaged, let us say, 100 computers? Let's say in a riot, they go into a particular college and destroy 100 computers. Now, what is the relative importance we have to give in cybercrime? In Indian law, we focused to define a cybercrime on the basis of crimes or offenses which are contraventions of law, which adversely affect an electronic document. So where an electronic document is a tool of crime or the object of crime, that is what is considered as cybercrime in India. The difference is we are just shifting the focus from the computer to the electronic documents. Of course, Indian law has been so intelligently drafted that the definition of computer in Information Technology Act extends to software residing inside it, maybe extending to the data also inside that. So using that extension, you can say computer also means data. Therefore, damage to computer also means damage to data. So to that extent, even the FBI definition can be extended to India. This is the strength of Indian law. That is, by defining certain common terms like a computer in such a manner that it applies to variety of, you can say, devices, some of which was not known in the year 1998 when the first draft of this act was done. Today, we have got a lot of variables, okay, your Fitbit and other things. In 1998, I don't think we had heard of such devices. We had not heard of Alexa or Echo or something like that. They are all devices which were invented after the Indian law came into existence. So, but today, we are actually looking at it as covered under Information Technology Act. Even this ransomware, ransom attack was not a cyber crime which we knew in the year 1998 or 2000 when the act was passed. 1998 was when the first draft was done. 2000, the act became effective. At that time, ransom attack was not considered or not recognized even by technology people as a sort of a cyber crime. But today, when a ransom attack happens, I am invoking the same law which was drafted in the year 2000 and say that this particular section is applicable to this. That is the beauty of the Information Technology Act. Whether it was done deliberately or it happened accidentally, we will not worry about it now. We will give credit to whoever drafted it like that. Similarly, when it comes to the definition of electronic documents, you must remember that as an educational institution, let us say you have got some examination answer sheets which have been marked in the OCR kind of sheets where there are boxes which have been marked in pencil, block or something like that. Now, let us say you are having a set of those documents and somebody destroys that, either steals it or tears it off. Now, what kind of crime is this? Is it a crime under IPC, which is, say, the theft of paper or, say, tearing off some physical paper? Or is it something more? Now, if you look at Information Technology Act, it defines every document which is processed in a computer or is being prepared for processing in a computer or having been processed in a computer, all of them are considered as electronic documents and data. Therefore, this vandalism of these answer sheets could be booked under Section 66 of Information Technology Act. That is how the width of Information Technology Act has to be recognized. In fact, I remember that in the very early days, somewhere around 2000, we had an incident in Chennai. I was in Chennai at that time. There was an IT company which was at that time itself was a mid-sized company, so it was not a small company. Must be even at that time had about 200, 300 employees. Now, in this company, one outgoing employee who was the team leader for development of an in-house software, he had resigned, and on the last day of his employment, he had made a copy of the software which he and his team had developed, which was actually a processing software which had enhanced the productivity of that organization, and because of it, this company had a slightly better market share outside with customers than any other similar processing companies. They were processing this financial information like your bills and invoice kind of a thing. So this person thought that he is the person who wrote the code for this, and so he thought it is his property, and then he downloaded this from the server onto his machine. From his machine, he went to the CD burning section, which was a different section in the company, burnt a CD, and then he walked out of the premises. Then he joined another company in Bangalore, and there he was doing a similar function. So in order to improve the functionality of his Bangalore company, which is the new master who employed him at twice the salary, he installed the same software in that company and started using it. And that company also started gaining traction with the customers, gradually poaching business from the Chennai company. But somewhere after 2-3 months, the Chennai company came to know that their software, which had a particular signature of a kind, was found to have been used by this Bangalore software company, and they filed a case. When this complaint was filed, the CEO of this IT company, who should be very knowledgeable about cyber crimes, he filed a complaint. I'm not talking about CEO, maybe the admin or whoever was that. He filed a complaint, and the complaint was first given as a theft of CD. So the company said a CD has been stolen from my company by such and such an employee or whatever is that. It was the police officer, whom we normally consider is not aware of cyber crimes, etc., who suggested to this company that you are saying something has gone out of your company, you are an IT company, therefore it must be something to do with Information Technology Act and cyber crime, and therefore he invited me to take a look at it, because at that time I used to conduct training for police there. This person was one of the persons who had attended the training there. So he was able to recognize this crime as an ITA 2000 crime, which the IT company failed to do. This is what I would like to avoid as we go forward, because the engineers and software people should understand something about cyber crime, so that they will be at least able to recognize a crime when it happens and call the appropriate persons. Of course, this particular company had other issues regarding evidence and other things, so we'll see. I will try to revert to this at some point of time during my presentation. But finally, when we threatened the Bangalore company that this crime has been committed by this ex-employee, but this ex-employee has passed on the benefits to you, therefore you are the beneficiary of this cyber crime, therefore we will be launching a legal process against this company. At that time, this company came for a compromise, and some kind of an arrangement was made, whereas that particular individual, of course, he had to suffer whatever law prescribed, which was 3 years imprisonment in that instance. So this is, I'm just quoting this to say that recognition of a crime itself sometimes is difficult. That is why I'm saying this examination system, tailing of the paper could be, I'm talking of the answer sheet, OCR answer sheets, is a cyber crime. It should not be just a crime which you file with the local police station. You have to go to the cyber crime police station and file it. So this is one of the aspects which Indian law has recognized, and therefore when we look at cyber crimes in India, we have to make a distinction. Are we talking of crimes for which the contravention is there in Information Technology Act, or are we talking of any crime which is committed with the use of the electronic documents? Nowadays, we are often coming across crimes like what we call as Nigerian frauds, that is lottery fraud or something like that. The press and others routinely describe this as a cyber crime, but actually this is actually cheating, which is a crime under IPC. Because it is committed with some electronic documents, we immediately think it is a cyber crime. Probably some aspects of cyber crime would be involved there if any section of Information Technology Act has been contravened in the process of commission of this crime. Remember, when we say a crime, it is not a single act. If somebody walks into your, let us say, college and then assaults somebody, assault is the more visible offense, but there is a trespass. There is perhaps a situation where the guard tried to stop him and he pushed the guard aside and came inside. So there was a first assault on the guard and then he came inside. So a crime is normally a combination of multiple activities. Each of these activities could be constituting different offenses. Now let us say after assaulting your admin in the computer science department, this person destroys some computers, or he goes to the examination center and destroys something. So here we have got a combination of IPC crimes, which is this assault, trespass, etc., and the destruction of information residing inside a computer, which is the cyber crime. So when you make a complaint, you should remember that there may be many instances when the actual adverse effect which has happened on the victim has occurred out of contraventions of both the IT Act and non-IT Act. And we have to ensure that investigations happen on both fronts, because sometimes one cannot be proved and the other can be proved, and certain times the offense may carry a lower, you can say, punishment in one act. Therefore, we would not like to give too much of emphasis on that. Whereas we would like to give more emphasis on the cyber crime. So the understanding of the modus operandi, different steps involved in the crime, and then trying to link each of these steps to a particular section is what is important. There are instances where both IPC sections and cybercrime sections are added in a single FIR and single charge sheet. The only precaution the police or the legal people have to take is, for the same offense, you cannot punish a person twice. But if one offense contains 4 steps, I can invoke 4 different sections for each of these steps. Not all of them have to be from ITA 2000. 2 can be from IPC, 2 can be from ITA 2000, and whatever it is. Okay. For the purpose of our definition of a cybercrime, so I normally say that we will restrict by choice to discuss only contraventions of Information Technology Act. Otherwise, the canvas is too wide. It is something which we have to do in a much larger situation. So, when we try to invoke a cyber law to a cybercrime situation, the perspectives with which we approach a cyber law like Information Technology Act may also be different between different kinds of professionals. For example, if you take the victims, if anything adverse happens to him, he will call it as a crime. And if he gets an email, suddenly he says that it is a cyber crime. So that person wants the law to protect him from the losses he has suffered, which may be loss of reputation or loss of money. So he wants to recover the lost money. And in certain cases where there are personal vengeance, he wants the particular accused to be punished. So the victims have this focus, what is there in cyber law, which will protect my loss and which will ensure that the person who caused damage to me will get punished. The lawyers and the police and the judges, their focus on what they look at Information Technology Act is, how do I prove an offense in a court with appropriate evidence and ensure prosecution of the offender. This is their objective. Apart from these two people who are students of cyber law, there are another category of people who are the business managers, the information technology people, information security people, business executives, who are all the people who would be in your vision as a sort of a career people. Now, these people look at cyber law for guidance on how do I adopt information security in the architecture of software design or in adopting security practices in terms of network security in order to prevent occurrence of a crime. Then if a crime happens, then how I can detect the crime, and then how I can gather the evidence. So the IT people should look at cyber law for those indications in the act which talk about information security, the need for compliance, and the cyber forensic aspects. Because of these different perspectives, the study of cyber law by a lawyer is different from study of a cyber law by an engineer. Okay, so since you are all engineers, don't study it only from the perspective of a lawyer, study it from the perspective of a techno-legal legislation. Now, why does these different perspectives exist? I have to share with you some of my thoughts. One is, I have an observation that technology people are often afflicted with what I call as technology intoxication. Just like these aggressive young people wheeling on city roads, some of the technology people feel they have the power of technology, they know more than people around them, and they try to show off their capabilities. And some of them are having visions of becoming an ethical hacker or unethical hacker with more money prospects, whatever is that. Maybe some of them are well intentioned. They want to remain an ethical hacker. They want to benefit by bug bounty, which companies give. But a lot of technology people, when they move into this intoxicated state, they will not be able to differentiate between what is to be done within the red line and what is not to be done. One recent example was this incident which I have just shown here. A technology person in Bangalore, he announced publicly that the government has come out with the Arogya Setu app, which was a contract tracing app, and made it mandatory. I don't like being made it as a mandatory. Therefore, I as a programmer hacked it in such a manner that I can always show green in my Arogya Setu app. And this person declares it openly and gives an interview with the publication, and the publication gives it out as a news article. Now, look at this from a legal perspective. Now, you are admitting that you committed a hacking of a government asset, and that is something which can be called as an offense under Section 70 of Information Technology Act. That is, in case the government had declared Arogya Setu as a protected system. Otherwise, it will come under Section 66, which is hacking or unauthorized access without the permission of the owner of the computer. And under hacking, minimum 3 years imprisonment would be there. Under Section 70, it would be 7 years imprisonment. Now, if by hacking into this, he has shown a green, for his status of COVID, then he is allowed to come to the employment scenario. And let us say he is unfortunately one of the persons who has COVID. Then he has infected somebody else. And that somebody else may be a person who dies out of that infection. Whereas this person himself may recover because he is an youngster. Now in that case, his hacking of Arogya Setu has caused the death of a person, and this person can be charged for murder under IPC, or in Information Technology Act, there is a section called Section 66F, which talks about cyber terrorism. And if this person, like the Tablighi person, goes around, infects a number of people, he can be charged under Section 66F, which has life imprisonment. Now, how did a person who is knowledgeable, who is an engineer, who is perhaps an MBA or whatever is that, is committing this mistake? Because he doesn't know or he doesn't recognize the existence of Information Technology Act. In fact, this is not a 2020 crime. In fact, way back in around 2013, I had pointed out a similar thing for one professional who was working in Hyderabad in Satyam Computers. This person had created a script to hack into IRCTC application for reservation for Tatkal booking. And he had put it on his blog also. And at that time also I warned him that what you are doing is not correct. You are actually not only created a tool for hacking a government asset, but you are putting it for free download on your website, and you are spreading it in the community, you can be charged for that. Fortunately, this person realized his mistake and withdrew, and therefore perhaps today he may be in a senior position in the information technology area. We don't know, okay? But this is what I call as technology intoxication, which affects technology people. You should all guard against that. Now, very recently, we had this Punjab National Bank fraud case. 11,500 crores. Punjab National Bank was cheated. Now, the press, everybody talked about it as a financial fraud and so on. Now, as an observer of cyber crimes, you should also look at how this particular fraud happened. This fraud happened because Punjab National Bank bought a CBS software for core banking from none other than Infosys, Pinnacle Software. And at the time of installation, the question was, the banks have a system called SWIFT. SWIFT is a system where one bank interacts with other international banks for transfer of funds. Okay, it works like a secured email service. So an authorized person from one bank in India advises another, his client bank, is a correspondent bank in another country, says that please pay $1 million to so and so. Based on this email alone, the other bank will pay. Okay, so that is a system like your telegraphic transfers or something like that. Now, this SWIFT system is a subsystem in the banking. When this CBS system was installed, somebody in the bank suggested to this person, a software person who had come to install, saying that don't link SWIFT system to the CBS system. We want that to run separately. We want this to run separately. Now, this IT professional did not understand what is the impact of such delinking of a transaction, which could result in liabilities to the bank. So he said, okay, client is asking me to give a certain configuration, though my software can configure a link between the SWIFT and this, I can also delink it. Okay, so he allowed installation of the software without linking SWIFT to the particular CBS. Therefore, it was possible to send SWIFT messages like emails and get 11,500 crores in terms of guarantee obligations on PNB, on which various other banks paid money. And someday this chain became broke, and Nirav Modi was not able to repay. Otherwise, he was doing what we call as kite flying. That is, take a new loan, pay the old loan. Take a new loan, pay the old loan, like kind of a thing. In one point of time, he could not do that. Therefore, suddenly the loans became bad, and this scam surfaced. Now, from the technical perspective, my question to the software person is, the person who owns and installs a CBS system in a bank is not installing a technology software. He is actually installing a banking system. It is like same thing with ERP kind of a thing. Don't look at it only as a software which will do some functionalities. It is not like a mobile app which does one or two small things. It actually manages the whole bank. CBS manages the whole bank. So in that case, if somebody says, don't add personal loans into this, don't add this loans into this, it means that the person who is asking for that is out to commit some kind of a crime. You are not able to recognize that. So I hold the software persons from Infosys for ignorance of how their tool can be misused in a bank, and that is evident in the Punjab National Bank scam. So whoever thinks of it as a cyber crime, managerial perspective from the bank, how to recover, that is different. From the IT perspective, remember there is a contribution of the software developer in this commission of the crime. Now, same way, you have all heard of this Uber automated car, which actually was involved in an accident because somebody was crossing the road. The software should have identified the obstruction and applied brakes. Okay, it did not. And at that time, there was a manual driver also sitting there, but he was not operating the brake or anything. He was just watching. and he's supposed to take control of manual systems if necessary. He also perhaps failed because the person crossed the road suddenly or whatever is that. So there was a manual failure and it was a technology failure. It created in a loss of life. Now when this case goes to the police or to the court, the question is, how do we consider this? Is it a cyber crime? Is it possible that Uber car failed because somebody had hacked into the system and disabled the system to some extent, which could have happened, or whether the software developer was negligent and there was a deficiency in the construction of the software, which perhaps caused this failure. In both cases, we will be pointing our fingers at technology people, not anybody else. Okay, so this is the kind of perspective which the IT people should develop whenever they see in a newspaper something has happened. Now, I'll come to something more closer to us. In all financial crimes, one common term which we hear is phishing. Now, phishing itself can be looked at by different people in a different way. And normally when a person loses money in the bank, he will just go to the police and the police will record it as a phishing crime. Okay, and there ends the matter. But what exactly is phishing? In fact, this came up for discussion in one of the cases in which I was personally arguing. I am not a lawyer, but I did handle some cases when lawyers were not ready to take cybercrime cases. Way back in 2008, I had taken one case called Umar Shankar versus ICICI Bank, which has still been rolling out in various legal forums. So recently, the appellate tribunal called TD SAT gave its judgment. Now it is with the High Court. Now in this particular argument, I actually tried to convince the court that phishing is often misunderstood. Sometimes phishing may happen through impersonated email. Sometimes it may happen because a website is faked. It may be also phone call. You have well perhaps seen Jamtara series or something like that, phone calls. So phishing is essentially impersonation. Now, impersonation is one part of the crime. That is not the entire crime. In the sense that somebody may have a successful phishing, end of it, he may get the reward, which may be the password of the particular person or the credit card number or whatever is that. That is the end of phishing transaction. Phishing transaction alone cannot result in a financial loss. But what happens is, while phishing happens in the customer's place, which is the computer of the victim, subsequently one more offense happens. That offense is unauthorized access to the banking system. A person uses the information he has stolen through phishing and then enters the banking system. There he sometimes creates an unauthorized beneficiary. Normally banks will say 24 hours, you cannot transfer, whatever is that. He will try to break that also if possible. Then he will have a fund transfer. Now this activity happens not in the customer's place, but in the banker's place, that too the bank which we call as paying banker. That is within the bank, there are two roles they play. One is the paying bank where the account is kept. So at the paying bank, this unauthorized access happens, unauthorized beneficiary creation happens, funds gets transferred to the unauthorized beneficiaries who may be residing in different places. They will have some accounts with their bankers. That is called the collecting bank. So fund withdrawal happens there. That is, unauthorized money walks into that account and then it is withdrawn. That is actually called money laundering. So that collecting bank is part of money laundering. The paying bank is part of hacking activity. The phishing happens at the customer's place if you break this into these three categories, you cannot make the customer solely responsible for having been ignorant in not recognizing a phishing email and then giving away his credentials. See, normally everybody blames the customer, saying that you are a fool, you gave away your password, you gave away your credit card number, so you please take the liability. What we were trying to prove in this particular case is, though the customer has been negligent to some extent, there is a greater negligence on the part of the bank. Therefore, we were trying to argue that the bank should be held liable. That is what two of the courts have so far agreed and have made ICICI Bank liable for payment of this amount. Now we have to see how it goes into the Supreme Court or whatever is that, because the bank has got the money to go to the highest court in the land. We are part of the victims and we have already lost money. We don't have money to go ahead. And this case is just lingering on because I am trying to help this person most of the time without any payment. So I don't know how long it will go on. Now it is all stuck in this COVID kind of a situation. Now, why I'm presenting this is, if you start re-looking at a particular offense, you will get new dimensions of that. I can extend this to a number of other examples. We will do it later. Now, with this kind of a background, if we look at ITA 2000, we will try to explore a few sections, and then perhaps we will try to also see if we can address a few more cases. ITA 2000 has got chapter 9, which talks about certain contraventions which lead to recovery of compensation for damages, which is called civil wrongs. Chapter 11 contains offenses, and the offenses will lead to imprisonment and a fine to the government. There are also sections which talk about vicarious liability, where the offense is committed by X, but another person may be held liable. Then there is also sections on powers of police, and then there are information security obligations, abatement and attempt. There is issues like cognizability, admissibility of evidence, etc. These are all the things which are there in the Information Technology Act. You need a lot more time to discuss all these things. I will only try to give a bird's eye view of that. In this chapter 9, there is one section called section 43, which has got 10 subsections, which talks about various ways by which the contraventions are recognized. This is also important for crimes because this for section 43 actions are linked to section 66, and whoever does this 43 contraventions, if they are having a malicious intention, that will be considered as a section 66 offense with a 3 years imprisonment. So 43 is both a civil wrong as well as a cyber crime. So in this, there are 10 subsections. It says unauthorized access is a contravention, unauthorized downloading, even if you had authorization to access, that is also a contravention. Unauthorized introduction of virus or computer contaminant is an offense. Damaging of computers, which includes hardware and software, is an offense. Disruption of a computer operation is a contravention and offense. Denial of access is an offense. Providing assistance to another person to actually contravene any actions of any provisions of Information Technology Act is also an offense. Charging of a service to another person, me availing a service and then charging it to somebody else, is also an offense. Then it uses a particular terminology. Any action which results in diminishing the value of information residing inside a computer is considered as a contravention under section 43. This is something which has got a stretchable meaning. What diminishes the value? If I have got a confidential information in the computer, somebody just looks through that, that is diminishing the value. If I have got a question paper on the computer, somebody hacks into my computer, views that question paper, doesn't make a copy, but he has unauthorizedly accessed this and then viewed. Even if I have given him access to one part of my computer, he made some search and looked at this document, which perhaps came up, then he viewed that, that has reduced the value of that question paper. So confidential information. So that is also covered under Information Technology Act Section 43. Then destroying what is called a computer source code is also an offense. When we use the term some computer source code here, we are not limiting to the software person's definition of computer commands as source code. We may look at even log records. We may look at the asset inventory inside a computer, all that as part of the computer source code. Now, all these things are contraventions. If somebody does this contravention and another person suffers some financial loss, then that financial loss can be recovered from the person who committed this offense. Now, for implementing this, the Information Technology Act has given powers under Section 46 to a person called adjudicator, and adjudicator at present is the IT secretary of each state. So next time when you conduct some cyber law related program, please invite the IT secretary of Maharashtra to inaugurate and address him as the adjudicator of Maharashtra. Maybe he himself may not be aware, but that is how you have to bring awareness even amongst the people who have been designated as adjudicators, because the adjudicator is like a civil judge for the entire state of Maharashtra. Any cyber crime in which somebody has to claim damage up to 5 crores, the sole jurisdiction is with the adjudicator. You cannot go to a civil court. Civil court will come only for 5 crores and above. Less than 5 crores, the adjudicator is the sole authority. So such is the importance of the IT secretary in a particular state. Now, when we come to the offenses, I try to bifurcate here based on different types of offenses. We have got one set of offenses related to data damage. 43 is one such thing associated with Section 66. Then there are two sections, 72 and 72A. There are offenses related to obscenity, which is 66E, 67, 67A, and 67B. Then offenses related to digital signatures, 66C and D are impersonation and forgery. Then 68 is for certifying authorities, controller of certifying authorities, regulating the certifying authorities. 71, 73, 74 for somebody taking a false digital certificate for fraudulent purposes. Then there is offenses related to information security obligations. Every organization is expected to have certain information security obligations. There is an authority who can come and ask for some information. That information you will be able to give only if you have this information security infrastructure in place. So that is covered under Section 69, 69A, 69B, 70B. These 69 and 69A are so powerful that if a company is not able to provide the information called for, the executives of the company may be liable for 7 years imprisonment. So this is something which cannot be underestimated. There are offenses related to evidence, 65 and 67C. There are offenses related to stolen systems. Use of a stolen system is an offense with 3 years imprisonment. Protected systems, Section 70, where even an attempt to access will be having 7 years imprisonment. Then cyber terrorism, which has got life imprisonment. So in addition to this, there is separately 2 sections on abetment and assistance. There is somebody who assists the another person to commit a crime successfully. He is considered to be an abettor, and he will be liable for the same offense as the particular person who committed the offense has got. Okay, if a person has made an attempt and did not succeed, then the punishment will be half of what is prescribed for that particular offense. So that is abetment and assistance. Vicarious liabilities are important because in corporate scenario, it says that a company will be held liable for the offenses which it itself may not have committed, somebody else has committed. Vicariously, it is held on the company. If any assets of the company are used in the commission of the offense, that brings vicarious liability. And when there is a liability in an organization, it gets extended to its CEO and the officials in charge of the business. This is what vicarious liability says. So these are all the different sections of the Information Technology Act. I don't have time to go through all this. We'll look at it differently. Now, powers of the police, it has been defined that any offense for which there is a 3-year imprisonment, it is considered as cognizable in the sense that the police can start investigation without a court intervention, but it is bailable so that the person may be arrested and given bail. If the punishment is more than 3 years, it is considered cognizable. It is not bailable at the police station level. It has to go to the court. Court always has got the power to give bail. If the offense has less than 2 years of punishment, then less than 3 years of punishment, then it is not cognizable, and therefore when the arrest will not arise, therefore bailability will not arise. Normally an inspector of a police station is the authorized person. There are also instances where an official of the government can be provided the power to investigate and even cause arrest of a person in a public place. So these are provided for in the Information Technology Act. Now, apart from what I have so far discussed in terms of cases, I would like to take a couple of other cases just to give you the dimension of how the Information Technology Act functions. The first case I would like to look at is Suhas Katti case, because Suhas Katti case was the first case of conviction under Information Technology Act. In this person was arrested from Bombay for having sent a defamatory message, or having posted a defamatory message in Yahoo groups, and he had at the end of the message given the name of a lady who was his friend, family friend, who was in Chennai. So that lady started getting calls from unwanted places, and she had filed a case without knowing who was the person who had posted this. Then after investigation, we were able to trace this gentleman and then bring him to the courts. He was convicted initially for 5 years, out of which 2 years and 1 year under different sections. So cumulatively it was 5, but totally it was 2 years. Then of course he went on an appeal in the Sessions Court. Sessions Court upheld all the charges but reduced the punishment term. This person was an engineer. He was an MBA, and he did not know that posting a defamatory message in Yahoo group, what he did was he went to a cyber cafe. He didn't do it from his house. He went to a cyber cafe, and in the cyber cafe register, he did not give his name. He signed it as Mary, the name of the person who he wanted to defame. So he thought perhaps he would not be convicted. It was 2004. So you can imagine the police at that time were considered as Buddhus. They don't know anything about this. But Madras police was different. Okay, they were trained under me and they were much more intelligent. Within 1 week of the complaint, we were able to trace this IP address of the cyber cafe, and the deputy superintendent of police from Chennai got permissions from his department to travel to Bombay and then continue the investigation. He went to the cyber cafe. He got the profile of this person. By that time, we were all so aware that there is a person called Suhas Katti who is known to this family, and nobody else is there in Bombay who could have sent this kind of a defamatory message. So this person was easily identified, and the cyber cafe owner also identified him, and he was immediately arrested. So within 1 week of the commission of the crime, in which the object of the crime was lying in Yahoo group server, this person was arrested, and within 7 months, the trial also was completed. All these 7 months, he did not get a bail, and he was in the jail itself. Now, this particular case was not only a proof that police could have acted like that, and also that we could prove the evidence sitting in Yahoo group server in a Madras court by using something called Section 65B certification, which I had given at that time. This was the first Section 65B certificate of digital evidence, based on which, without the production of the original document, evidence is admitted and conviction happened, and it was a serious conviction. So the Suhas Katti case is important in that sense. Umashankar case, I told you, it is important because historically this is also one of the first cases in which the bank was asked to pay the money to a phishing victim. Then there was this Bozzy.com case, which happened again in 2004. This was the case of an IIT Kharagpur student who posted an obscene video as a saleable item in this Bozzy.com, which was a peer-to-peer e-commerce website, and he tried to sell it and he sold it to 7-8 people, but the police asked him, you are publishing and distributing obscene material in electronic form, which is an offense under section 67 of Information Technology Act, and therefore he was arrested. While arresting that student, IIT Kharagpur student, they also arrested the CEO of Bozzy.com, saying that you have given the platform on which an offense was committed, so vicarious liability rests with you. And since I cannot arrest the company, I am arresting the CEO and one general manager. 2 persons were arrested in the Bozzy.com case. It took them 8 years and fight in the Supreme Court to get themselves released from the obligation, which happened only because of some technical issues. Otherwise, these people would have been in jail for the same 5 years or whatever the judge considered it reasonable, though they themselves were not as seriously involved in the business of pornography as this individual student was. But the argument is Bozzy.com benefited by the commission on the sales and it provided the platform, so they must hold the responsibility. This is called intermediary liability, which is a big issue in cybercrime cases. If you go through Naavi.org, my main site, I have several times held that intermediaries must be held liable, without which you cannot control cybercrime. You cannot always say, I will be able to catch hold of a criminal who is a Nigerian fraud criminal who is sitting somewhere in Russia or somewhere, that kind of a thing. You can only catch the intermediaries who facilitated the crime. And in Umashankar's case also, the court agreed with this contention, and they said that not following security practices as recommended by the Reserve Bank of India is a passive assistance to the commission of the crime, and therefore under section 43 subsection G, providing assistance to commit an offense was recognized because ICICI Bank did not follow some RBI guidelines on security, etc. That is what was the key aspect of this Umashankar's case. This section 66A striking down is also important for us to recognize in another manner. You know that there were certain instances of Palghar girls who posted a Facebook information was arrested, and somebody who liked that Facebook, she was also arrested because the police filed the case, and in filing the charge sheet, they used section 66A of Information Technology Act. So like that, there were several other cases, and somebody went on a PIL saying that section 66A is so obnoxious that it could arrest people like this. Though these Palghar girls were not to have been arrested at all, the fact that the police did not know that what was the kind of offense and they booked it under section 66A, the magistrate committed these people to 15 days imprisonment without understanding again section 66A. It went to High Court, it went to Supreme Court. Nowhere the courts were able to identify the correct nature of section 66A, and ultimately, instead of pulling up the police who misapplied the law, they actually pulled up the section 66A itself. Otherwise, section 66A was a section which was meant to cover cyber stalking, cyber bullying, spamming, and phishing. And in addition, it addressed sending of threatening emails. Now, the section 66A was only applicable to SMS and emails. It was not applicable to postings on Facebook. It was not applicable to postings on Twitter, where they were publishing. Whereas this was only messaging. Section 66A clearly said offense related to messaging of application. It applied only when one person sends a message to another person and causes harassment to that other person. which can happen only in a one-to-one communication. Publishing is a different system where the message is available in some platform, people go there and receive it. It is like a publication. So what was applicable for a messaging was applied by the police and approved by the courts, including Supreme Court, as applicable to publishing. And they said there is a freedom of speech issue. Here we have a chilling effect if this is allowed, and therefore they struck down section 66A. This was the most infamous case, what in my opinion, called Shreya Singhal case. So these are some of the cases. Maybe we will take 5-10 minutes of questioning if there are any questions now before I go into the next section on digital evidence, which is also important for all of you as technical persons. Yeah, if any questions are there, this is the time to ask about the cyber crimes which have come so far.
Any questions from the participants?
Yeah, questions can come even from the faculty. I have no problem. Any questions?
Sir.
Yeah.
Sir, I wanted to ask one. I had an experience with my friend that she was recruited by some company, and she accidentally sent a mail from her official account to her personal account. And then she happened that she had to lose a job. It was her dream job, but she had to lose it. But what exactly went wrong in that case?
Now, this is more like an employee indiscipline. There would be, in data protection, we discuss something called data exfiltration. That is, from the company, data going out. In this particular case, there would have been a sort of an agreement in the employment that she should not forward anything from their official email to the personal email. Basically, it is meant to protect the corporate assets. Like, you don't have to send a company's document to your personal email. Okay, that is the purpose of this thing. The case which you are talking of is the person has committed in sort of an indisciplinary action by sending some message from the official ID to the personal ID. That is one part of it. But if she has sent only her own CV or the message she had received from another person, Naukri.com, then she has not actually adversely affected the company's assets, except that she has used the company assets to take another employment kind of a thing. So it is a disciplinary action which the company has taken. You have to look at their HR policy, whether this is a reasonable punishment for this particular action. Otherwise, it appears that it was very technical. It's a technical error. Perhaps the company has taken a too strict a view of this. That is my opinion as of now. So there must have been a provision in the HR policies. They must have executed that. Okay. Fine.
Hello.
Yeah.
So there is another question from Suyash Jadhav. Shall I read it out?
Yeah. That is digital transformation.
Please throw light on data protection bill, its controversy, and is it really going to breach privacy of Indians?
Data protection law is not to breach privacy, it is to protect the privacy of individuals. Don't be guided by the misrepresentations of the press. Say, you want to protect the privacy, but protection of privacy is only possible by protection of information related to privacy. So a data protection law comes into being, and data protection law says, I will protect the privacy of the individual by asking the individual how does he want a collector of personal information to dispose of the data, and trying to adhere to that. If a company collects the data for some purpose and uses it for a different purpose, this law tries to punish that person. So it is a misconception to say that this act will not definitely create any breach. It does give powers to some government authorities, which has to be there for cybercrime prevention, and the government authorities get some kind of an exemption. That is what is being misrepresented by some people. The government is going to breach your privacy. No, if somebody else breaches privacy, government will impose fines and other things under the Personal Data Protection Act. Government has powers because it should have powers, otherwise cyber crimes will happen. What about, say for example, there was a situation in Kashmir some time back. There were stone pelters who were all paid money, and the money had been paid through Paytm. So government wanted Paytm to give a statement of persons to whom money was paid during a particular period of 15 days or whatever is that. Now, Paytm gave that information, and many people said it is privacy breach. No, it is not privacy breach, because police were investigating a possible crime, and one of the elements of the crime is distribution of money. That happened through Paytm at that point of time. So they asked Paytm to share that data, and they shared that data. So this is not privacy breach. The PDPA provides exceptions. Okay. This personal data protection is going to be the future career maker for engineers. Okay. Now, within about the next 1 year, this act will be in place, and whenever you go for any interview with any IT company, the first question you will be perhaps receiving, or the second or third question will be, do you know what is data security? Do you know how you can protect, how you are supposed to protect it if you are my employee? In that case, your knowledge of Personal Data Protection Act becomes the key differentiator between you are getting employed against another person who may have equal marks or something like that. In fact, you should visit Naavi.org. From tomorrow, I'm starting some course exclusively on PDPA. Those of you who are interested can look at that. Basically, persons who are going into the placement in the next quarter or something like that, look at that knowledge. You may not immediately getting into employment because it will be 1 year down the line, but that by that time, the act will be fully enforced, and it should help you. Okay, so that is Personal Data Protection Act. Don't be misguided by the press reports. Please look at it as an attempt by the government to protect the privacy. Successfully or not, we have to wait and see. Okay. Then,
so there is another question.
Yeah.
Chat. GOI, Government of India, is promoting for digital transformation. So how secure and reliable is it in cyber law point of view?
See, digital transformation is happening by saying promoting use of digital payment systems, okay, use of Aadhaar kind of a thing. Now, as long as you use a digital system, there is always a scope for cyber crimes like the UPI system or something like that. So that risk is there. Now, for example, cyber crimes don't happen only to Indian government related activities. It happens globally. It happens to the best of companies. Cisco is affected, Microsoft is affected. If you think there's a better company than Microsoft, tell me with so much of knowledge. But Microsoft every week has to release a patch, because not only because of functionality, but because of security breach one way or the other. The ransomware like WannaCry came in because of some vulnerabilities in Windows XP system. So there are technical vulnerabilities. There are cyber criminals spending hours together to find such vulnerabilities, and then collaborating amongst themselves in the deep web, and then launching an attack. So cyber crimes is a possibility. It does affect the digital transformation also. So the solution is not to prevent digital transformation. Solution is to build cyber insurance. That is, one, insurance by way of making each of the user more aware. That is one minimum thing. Secondly, making all the intermediaries more responsible. In fact, just yesterday, we had a news that Paytm has filed a case in Delhi against the telecom companies, saying that phishing is happening because of your negligence. We are losing the money, as Paytm or any bank or something, we are losing money. And people like Vijay Shankar are saying that banks should pay the money for phishing. But actually, The problem is with the telecom companies who are allowing this phishing activity to happen. It's a very interesting case. I would watch what the court will decide. So the lack of awareness of the users, the lack of responsibility in the case of intermediaries, they cause cyber crimes, including the software developers who release software in beta version with all the bugs in there, which are called zero-day vulnerabilities. It is easy to give a name to that, but what is the right of a software developer to release a software with zero-day vulnerabilities, which will be exploited by somebody else against some innocent citizen? So the last level of coverage is cyber insurance. I have been asking the government of India to provide cyber insurance for all. See, risk is not only to the farmers who commit suicides or something like that. What about cybercrime victims? Because of the government's pushing people towards digitization before they are ready. The only way it has to be done is not to ask the government to avoid this, but to give some kind of an insurance. In fact, some of these companies, at least Paytm, had made an announcement sometime that up to 5,000 rupees they give a group insurance cover. I'm not very sure of that. Like that, government and these intermediaries, bankers, should provide cyber insurance cover. There are also independent cyber insurance policies you can take. It's about 0.75% of the insurable amount for individual policies. So that is the way to move, instead of looking at the transformation, because transformation will happen. Technology has to develop. Okay. Then, huge number of cyber frauds, current laws sufficient to handle. Current laws are reasonably robust. Implementation is always a problem. Police have too many cases on hands. They don't have time to investigate. So that is an implementation problem which has to be addressed. But law, as I told you, section 43 is quite robust. Then, if I download any software, it is asking for access to photos. Now, if that access to photos or information is relevant for the provision of the service which that software is providing, then they can ask for this permission and get this permission by consent. If you don't give the consent, they may not give you the service. That is an option which you have to exercise. So this Personal Data Protection Act ensures that these companies will ask only for such information which is required for providing the service. If they ask for excessive information, PDPA will punish them. But right now, PDPA is not yet in place. We are only having section 43A of Information Technology Act, which is a proxy or substitute for Personal Data Protection Act. Under that 43 capital A, there is something called reasonable security practice. Under the reasonable security practice also, purpose-oriented collection of personal information is mandated. If somebody is collecting excessive information, then under 43 capital A, you can claim compensation if you have suffered any loss. Zoom bombing is something different. That is, now we have had a Zoom session. I have made people come into this without even waiting in the waiting room. Now it's possible that somebody who is not invited may join here, and suddenly he may pop up and he may start making noise, etc., may disturb. That is Zoom bombing. It can now the latest versions of Zoom are having a lot of security processes. You can make people enter only on registration. You can make people enter only with a password. You can put them in the waiting room. Don't allow them inside before identification. All these things are possible. So Zoom is much more secure today than any time earlier, particularly if you are using a paid version. So, in fact, I am one of the persons who is using Zoom. And there is a YouTube video in which I have spoken about this Zoom also. Okay. Now with this, I think we'll go back to the presentation and go into another interesting area, which is the evidence. Then we'll again have another question and answer session in the end. Okay. Now, this digital evidence, there is a lot of misconception about digital evidence right at the level of the Supreme Court itself and many courts, including Bombay High Court. So there is need for judges to understand digital evidence properly, and it is the responsibility of the technology people to give them a proper explanation. But when we talk of evidence, we look at these issues, whether digital evidence is admissible in a court of law, and what is this admissibility? Is it same as genuinity? Then what is the process under which digital evidence has to be presented to the court? Can a oral electronic evidence be presented, or oral evidence on an electronic document be presented? Some of these things, even the courts are not clear. Is there something called primary document and a secondary document in electronic evidence? When can a forensic expert provide oral evidence for his submission? And is there any certification required? What are the conditions this certificate has to fulfill? These are the issues which come under digital evidence. A very detailed description of this is available on my site called ceac.in, Cyber Evidence Archival Center. Those of you who are interested can go into that in detail, but I will try to explain some of the aspects. In one of the cases in Supreme Court in 2014, Supreme Court said that evidence is constructed by the plaintiff and challenged by defendant. So admissibility is at the time of the presentation, and at that time certain rules apply. Then the other party can question the genuinity, then some different rules will apply. So for the admissibility, this section called Section 65B of Indian Evidence Act is relevant. That is what the Supreme Court said, and it said it is mandatory to have Section 65B certificate. Admissibility, if you look at from the ITA angle, already there is legal recognition of electronic documents, but then the Indian Evidence Act also says that electronic documents can also be evidence, and there is a procedure for admission. So that is how between ITA 2000 and Indian Evidence Act, the digital evidence needs to be presented. So the under ITA 2000, Section 4 gives the legal recognition of electronic documents as equivalent to paper documents. You have to read that along with Section 1, subsection 4, which has got certain exemptions. These are the type of documents which do not come under Information Technology Act. So leaving that, Section 4 says every electronic document is equivalent to paper. Then there is Section 5 coupled with 3 and 3A, which talks about digital signature, electronic signature, and what is the effect of applying a digital signature to an electronic document. So creation of this is part of ITA 2000. Now in Indian Evidence Act, there is a Section 3 which says electronic evidence is acceptable. Section 17 which says this is one of the third kind of evidences, which is oral, documentary and electronic evidence. Then it talks about oral evidence not permitted for electronic evidence, both 22A and 59. Then it comes to Section 65A, which says that electronic evidence will be admissible only as per the procedure given in Section 65B, and then Section 65B goes on to give the description. Okay, so I will go directly to this Section 65B and tell you what is important for us to note here. All of you know that an electronic document cannot be taken on record by the judge directly. Why? Because the original electronic evidence is in binary form, and the judge cannot make anything out of the 0101 or something like that, and he has to call an expert. And the experts may have different views about this stream of zeros and ones. For example, if these zeros and one streams are looked at along with the spaces which is there after every 8 digit, then they may be certified by some technology person as a combination of numbers 84, 105, etc. But if somebody reads the entire thing as a continuous zeros and one stream and the spaces he ignores, why does he ignore? He may say that it is a convention to segregate this, otherwise this is one single number. Then he will read it as a single large number. If you put this into a binary converter into ASCII, it will give something called TIRUPATI. If you want, you read it as Tirupati. Otherwise, you simply say TIRUPATI. And if you are using a different font system, it may come up in a language. So the same zeros and one sequence is looked at as 84, 105, etc., or 608, etc., or Tirupati in English, or Tirupati in Kannada, or Marathi, or whatever is that. which means that a single electronic document has multiple interpretations, each of which is true based on the type of conversion which the person has adopted. If I use a binary to number converter, I will get some number. If I use a binary to text converter, I will get a text. If I know a language, I will say this is Tirupati. If I don't know the language, I say it is just some jumble of figures. So what we call as evidence is actually interpretable by different systems. This is something which has been missed by many of the lawyers, and they think that every electronic document has got a single meaning. It doesn't have a single meaning. It has got a meaning relative to the conversion systems which you have used. That is something which our law has recognized. Our law has recognized that there is nothing called original electronic documents. Original electronic documents cannot be presented before the judge because he cannot make head or tail out of it. He can only interpret the original electronic evidence by using some computer of choice and then see what appears on his screen, and that is what he calls as evidence. So bringing this into the evidentiary system, the Indian Evidence Act has said that we will not try to give too much of importance to primary or secondary in electronic documents. We will call something as a document, that's all. Now, technically speaking, you can say the original electronic document is a stream of binary impressions created for the first time when an electronic device captures an incident. For example, if you take the example of a digital camera, if you click the digital camera, some impressions of zeros and ones are recorded in that memory card. That is the original image. Now, when that memory card is read through a computer, etc., you get to see an image. So here, the original electronic document is zeros and ones captured by the digital camera, first stored in the memory card. Then you make a copy of it onto a computer or a CD. That is a second copy, and from that you are viewing it on a computer. Even if you put the memory card directly into the computer, what you are seeing on the screen is a rendition of the zeros and ones by the computer which you are using. If your computer is not equipped with certain things which are required to read this document, it may fail to read it. That is why every electronic document is relative to the process under which it was observed and by the person who has observed. So these two things have been brought into section 65B, and the dilemma of how to interpret has been solved. And what section 65B says is every electronic document has to be produced along with a certificate, and when that certificate is produced, then we will forget about this primary and secondary evidence which are covered in different sections of Indian Evidence Act, and we come to the special provisions. The special provisions are written in section 65B. Now, there are many instances when people refer to a hard disk and say, this is the original evidence. That is not the original evidence. The original evidence is sitting inside the hard disk in the form of certain binary impressions. If it is a hard disk, it may be magnetic charge impressions. If it is a CD, it is lying there as your say pits and lands. Okay, so some impressions of a different kind. So there is no way by which you can call a CD or a hard disk as this is the original evidence. We have to only say that this is the container which contains the electronic document, which is the subject matter of evidence. Even if you produce this memory card from a digital camera, that contains a lot more information than what is the evidence you are talking of. That your evidence is only a few, perhaps MBs of bits, which is relevant. Before that, there are certain information. After that, there are certain information. So when the memory card is presented, you are still presenting a container of electronic documents. Out of that several things which are there, one sequence is what we call as the evidence related to a particular situation, crime. So hard disk is not original evidence, CD is not original evidence, unless we are able to understand that digital evidence is represented by the binary value. We will find it difficult to convince people about the need for this section 65B certification. Many prominent advocates also don't recognize this difference. Probably they are all, you can say, tuned to the present level of looking at primary, secondary evidence in paper documents. They are unable to unlearn what they have learned over a period of time and relearn what is there in the Information Technology Act coupled with Indian Evidence Act. So technology people need to actually provide this kind of an awareness to the advocates and explain why this certification is required. This certification is something which says this is what the particular sequence of electronic document means. When I have read it in my computer, which is using this kind of a system, etc., I take a printout of that and sign. That is called Section 65B certificate. Section 65B, over a period, over 5 different subsections, provides the different requirements. The very first subsection, I want every one of you to go through this section in detail or look at the articles which I have written, the ebook which I have written. The very first section introduces the term computer output, and it says that electronic documents which are to be presented as electronic evidence, if it is produced as a computer output, then original need not be presented. The reason why Suvaskati case succeeded is we did not bring the Yahoo group servers hard disk into the Indian court. I sat in Chennai, looked at groups.yahoo.com in my computer, and I came upon a particular page and I took a printout of that and said that this is what I saw when I went to www.groups.yahoo.com, made a search for something, and then scrolled down all the messages. This particular message number 8546 came up on my computer. I took a faithful copy of that in my printer, and I am certifying that this is a faithful reproduction of what I saw yesterday, day before yesterday, or whatever was the date and time. And that was presented in the court, and that was accepted as the conclusive evidence that such a document existed in cyberspace, and that is what Section 65B does. That is, production of a computer output is admitted without the need for production of the original. So this is something which we need to remember. Then the subsections 2 and other sections talk about what is a computer, what should be the conditions of the computer and other things. There, if you don't read subsection 2 along with subsection 1, you get confused. That is, subsection 2 says there should be a lawful owner of the computer. Many people say that if I'm taking the document from Yahoo, then Yahoo admin is the person who is the lawful owner of the computer in which the electronic document exists. That is not the intention of the Section 65B. It is when the computer output is produced, whoever produced that computer output, he should be the lawful owner of that computer, and the particulars of that device and the process has to be mentioned in the certificate. And the Section 65B subsection 4 prescribes what should be the contents of the certificate. It says that you should identify the electronic document which you want to be admitted as electronic document, which is printouts of the individual pages should be there. You should identify the devices with which you produced that, the process, which software you used, etc. Then who has done this? That person has to sign there, and he has to give a statement that in good faith he has produced this kind of a thing. So that is the requirement. If those requirements are fulfilled, the document becomes admissible. After it is admissible, if the other person wants to challenge, he can challenge it. He can bring his own Section 65B certified evidences to disprove this particular thing. If he wants to say that this is not genuine, then also he can do it. If the court is unable to decide between two people producing contradictory evidence, they can call a forensic lab who is accredited under Section 79 capital A of Information Technology Act for the purpose. There are about 5-6 institutions in India like that. They can ask that digital evidence examiner to help the court in appreciating which is the correct evidence if both are different. That is what Section 65B says. I will skip over the actual sections, but this image should be entrenched in your mind that the original electronic document originates in one device. Subsequently, it may be stored in some different device also. It is first stored there, then copied. Then observation may happen by the certifier in a different device, and the person who observes it converts it into a computer output. So there may be multiple devices which are involved in this process, and the certifier will only certify the computer which he has used for producing the computer output. The courts even today are not fully aware of this nature. I have come across many court judgments, one of which very important judgments was called Shafi Muhammad judgment, which contradicted the earlier judgment of this Bashir case. Bashir case in Supreme Court specifically said that Section 65B certificate is mandatory. Admissibility is different from genuinity. At the time of admissible, Section 65B certificate is the only criteria we have to look at. Genuinity can be questioned subsequently. So this settled the case. Prior to this, 2004, when we presented this in Suhas Katti case, it was admitted in the court, but it was a small court. Nobody thought it was creating a precedence. Then in 2005, there was Afzal Guru case in Supreme Court, where the Supreme Court, depending upon the exigencies of that case, actually admitted the evidence without Section 65B certificate, and that became more or less the precedence which went up to this 2014 when Bashir judgment came, when the same Supreme Court, a 3-member bench, said that Section 65B certificate is mandatory. It was mandatory from 17th October 2000 when the act came, but it was recognized by Supreme Court only in 2014. So 14 years, the judicial system was blind to the fact of what is Section 65B, despite awareness efforts made by me. And even today, I am sure that many people still don't agree with me. This is one area where differences still persist. Now, subsequent to this Bashir case, there was another important case in Tiwari versus Arjun Singh, which said that when you transfer an electronic document from one state to another, copy, each of the copies should have contemporaneous Section 65B certificate. The person who transfers it from one to the other should say, I had this in this particular system, I transferred it to this system, I certify that this is same as that. For which, if it's an electronic system, they can use hashing or something like that. Okay, so that is a contemporaneous system concept which was introduced by Sharendu Tiwari versus Arjun Singh. Then there was a case on Sonu Amar Singh, which was a retrospective effect. This was a practical decision. The court said that we will not reopen the old cases which were decided without Section 65B certificates, because it would be too impractical. Because from 2005, or in fact from 2000 itself, until 2014, a lot of convictions had happened without Section 65B certificate. One of those convicts applied to the Supreme Court saying that I have been convicted by using of an electronic document without Section 65B certificate, therefore I should be released. This person was a kidnapper and a murderer, and the court obviously did not want to give him any leverage. They said we will not reopen the old cases. Shafi Muhammad was a misjudgment, because this case, 2-member Supreme Court judgment said that Section 65B is required only in cases where the person who is presenting the evidence is in control of the device in which he is presenting the electronic document. If the document is being presented from a different device, he said Section 65B certificate is not required. which meant that if there is an electronic document from your computer or your mobile, then Section 65B certificate is required. If you are taking a Facebook page or a web page, then because that is in the custody of Facebook or Google or some other person, you don't require a Section 65B certificate. This was definitely very, very illogical, because what Section 65B certificate was more required in the other cases where the computer itself was not in my custody, because if a computer is in my custody and I'm claiming this evidence is in this computer or this mobile, court can always summon and ask me to deposit it to the court and ask an expert to come and evaluate and certify whether what I'm claiming is true or not. But when I'm saying something was there in Facebook yesterday, no, today it is not there. Now, I will not give you Section 65B certificate. I will only give a printout which I have taken yesterday, and Facebook will not come and give you, I had a version yesterday, version today. So this Shafi Muhammad case would give rise to a lot of false and fake electronic evidences being presented in the court. So this particular judgment is now under review. I hope the review bench will take the appropriate decision. It has not yet come out, it may come anytime. The appropriate decision is to say Section 65B is relevant. So without that, it is not possible to change the law, accept any electronic evidence. We never know after Section 66A whether Supreme Court will be self-logical. They may say that Section 65B is not logical and strike it down. They have the powers, but I hope it will not happen this time. So this is basically what I wanted to discuss. I think we will take some more time for questions. I hope we will have enough questions now to spend for the next 15 minutes. Yeah.
So there is one question from Jaya Madam.
Yeah.
How responsible a staff is held if a mischievous act is done by a student, and if something happens like that, the lab, like we have a lab specialized for cybersecurity, what should be done by staff?
See, your educational institution is like any corporate entity. Like a corporate entity has a CEO who talks about policies. There is a CISO who actually implements that. An educational institution also has got whoever is your head. You can call principal as the head or dean as the head, I don't know. That is your administrative structure. There is one head who is responsible for the administration of the institution. He is the CEO. Now, he has delegated the responsibilities of managing cyber assets to one set of people. Normally in engineering colleges, the computer science department or information security department will be managing the cyber security for the organization. There may be 1,000 computers in your premises, and they are all being used by your students, and many of them may use your Wi-Fi system and bring their own system. So that is similar to what we call as BYOD in the corporate scenario. So risks are definitely there in any of your students misusing the network and committing crimes. The crime may be as simple as sending a terrorist message out of your network with your IP address, and the police have got nothing else than coming and questioning you because you are the owner of that IP address. Now, whether you as the administrator, whoever is the administrator, he may be the head of the department of the computer science department or whatever is that is internal structure. Whoever has got the ownership of the network, okay, that person, police will ask, what is this IP address? This IP address belongs to you. Now tell me who has sent this message. Now you should have an internal system in which you should be able to trace that IP address to one single computer which is used by one single individual and say this is done by so and so. Then the police will start questioning that person. In case you do not have a system of identifying the users, and login IDs, individual passwords, etc., then you will be telling the police, I don't know who has done this. The only thing police can say is, if you don't know, then we will look at you as the person who has committed this offense. You come and explain to the court. So the executive head of the network becomes answerable to the offenses committed through the network. There is a section 79 in Information Technology Act, which is something which provides exemptions to such people, that is the intermediaries. You can say that I am an intermediary, I am only maintaining the network, the students are allowed to use this, I cannot filter every message or something like that. Then if you are claiming to be an intermediary, then you will have to look at section 79, and 79 says that if, first of all, you are not aware of an offense being committed, I agree that you are not aware. The second aspect which in section 79 says is, you should have exercised due diligence. If you had exercised due diligence, then you will be exempt from the offense. You will not be held liable for the offense. I gave you the example of Bazi.com. Bazi.com CEO and general manager were charged with the offense of sending an obscene information, though that had been sent by one of the registered members of their service. So they were as much innocent as anybody else, but courts expect, or the law expects, that you should have a security system which will make it, if not impossible, difficult for people to use your network for commission of the crimes. In the case of Bazi.com, when somebody registers himself as a seller, the same thing may happen in OLX or Quicker now. It's a peer-to-peer marketing network. Now, somebody registers and then he puts up a particular asset for sale. Now, the asset has got a name. Okay. In this particular case, it was an electronic file. It was called a DPS MMS video. Now, at that point of time, 2004, everybody in India knew what was DPS MMS video and what it contained, because the TVs had discussed that in great detail, like this boys locker room case now. Now, if somebody says boys locker room video, people know that it may contain this kind of an information. Like that, DPS MMS video contains certain obscene activities of two minor students, and that was well known because of the publicity. Now, when in my platform somebody sells it by that name, if I have got an intra-site search facility, that search facility should have highlighted that this illegal particular video is being sold on my platform, and I should have taken action to get it removed. Court felt that Bazi.com did not have such a facility. They simply gave one terms and conditions and said that you will not post this, you will not post this, and somebody just clicks at the end of that statement, and you think that you have done your due diligence. That is not acceptable. In fact, in India, click-wrap contracts are not having legal sanction. It is only an implied contract. So therefore, Bazi.com CEO and the general manager were co-charged with the same offense as that of the IIT Kharagpur student. Same thing can happen in a college situation. If any of the students commit a grievous mistake or an offense, the police have every authority to hold the head of the institution and the person in charge of the network liable, unless you defend yourself from what is called due diligence. So all the cyber security practices which an Infosys or a Wipro will have, same approach has to be done by the educational institutions. You should have a CISO, you should have information security policies, you will have to have data protection policies. When this Personal Data Protection Act comes into being, you will be called a data fiduciary, and any of the information of the students you collect, which you collect in thousands, some of the people who have applied and did not become a student, some of the people who have studied here for last 10 years, all that information is available with you. There is sensitive information about biometrics and other things. You will be called a data fiduciary, and that too, with serious repercussions on any of the data being leaked out. You will be called actually significant data fiduciary. Smaller schools which have students below 18 years of age will be even called guardian data fiduciaries. And there is a compliance requirement there. You need to appoint somebody as a data protection officer. Not appointing a data protection officer itself is a violation or contradiction of the Personal Data Protection Act, which may involve fines up to about 5 crores of rupees. So the law is very clear, and it is becoming even more clear with the PDPA that the intermediary has a liability. So therefore, any mistake done by your students, if you have not adopted appropriate security policies, it will land the organization in problem. And if you are the person who is in charge of the security, you should be ready for police to question you. Okay? Not easy to accept, but that is the situation. That is why you need to have appropriate security policies, as if you are an Infosys, as if you are a Wipro. Now, Infosys and Wipro will be having a CISO who is paid 5 lakhs of rupees per month or something like that. You may not be able to pay that much, but the kind of quality of security required in your organization is same as that which is required in an industrial establishment. Okay. Now, crimes pertaining to industrial control systems. Certainly they are cyber crimes, not only industrial control systems, even hospitals, even in ATM. You look at an ATM. What is an ATM? ATM is a Windows XP computer, perhaps. Okay. So all electronic devices, I gave you the example of the medical devices, heart implants, maybe the Fitbit kind of a thing, Alexa. They are all devices, but they are all electronic devices. Any device which can process a binary information is called a computer. So if there is a CNC machine which processes electronic information, it is a cyber device, and any unauthorized manipulation of the operations of such a machine is a cyber crime. One famous example of this is Iran had a nuclear processing facility. They wanted to secure it in such a manner that nobody can attack it through internet, because internet is the major source of risk. So they actually created what we call as an air-gapped system, constructed a facility 50 feet below the earth so that even your Wi-Fi devices from the surface will not reach there. And they set up a nuclear enrichment plant which was running certain centrifugal pumps, which was used for processing the uranium for enrichment purposes. But somehow a virus entered the system, and what this virus did was it attacked only the Siemens centrifugal system, and it reduced the speed of rotation of a centrifugal pump from say 10,000 RPM to 5,000 RPM, but the dial which shows the RPM will be showing 10,000 RPM. So if somebody sets a 10,000 RPM, the rotation will happen at 5,000 RPM, but you will not come to know because the dial is still showing 10,000 RPM. Now, because of which the whole batch of the uranium failed to, get enriched or whatever was the process which was involved. So similarly, it can happen in any CNC machine. All industrial machines have got sensors. Sensors send electronic messages. There is a processing, and the processing has got a filter that if the sensor reading is so much, you should open this valve. If the sensor reading is so much, you close this valve. You increase the temperature, decrease the temperature, you add this or something like that. When the temperature reaches so and so, open another valve, so another ingredient will fall into the bucket, something like that. Now, if somebody hacks into this system, either with a malware like what happened in the Stuxnet case, this was what I described in the Iranian, this thing is called Stuxnet virus, which was supposed to have been created by the US government or somebody, but whoever did it, but it was a particular kind of malware. It can happen through that, or it can happen through otherwise direct hacking, impersonation, phishing, etc. Definitely it is cybercrime. That is why all mechanical engineers who are functioning now should be aware of this cyber law. There is no business activity today happening without the use of computers. And computers are not used only for HR or salary payment. It is used for actual processes. Therefore, everywhere this incident of cybercrime can happen. Yeah, other questions? IRM, what do you mean by IRM? What is the role of IRM? Abbreviations, can you please? Okay. Hacking is not difficult, but staying in jail for 3 years is certainly not easy. Okay. So whoever thinks of hacking for the purpose of fun should remember that they have a seat reserved in the jail for 3 years. Maybe you will have Vijay Mallya as company. What is the role of IRM? What is IRM, industrial control thing you are talking of? I don't know. Information rights management. Okay, this comes under the copyright issue. Okay, you introduce certain controls so that if somebody makes an unauthorized copy, etc., it will come to be known. Okay, it is the within the powers of a owner of an IPR, the copyright, to introduce such systems. If you break that information right management system, that is hacking. In fact, one such case happened long time back when there was a software developer called Dmitry Sklearov in Russia. He had created a software for his company. He was a project leader and a senior employee of a company which is even existing today. It's called Elcom Soft, which is well known. Okay, they had a software which was converting the PDF ebooks into other formats. That was the simple purpose, and it was available on for download from this Russian website. Anybody could download, even people in USA could download. But what was happening in this conversion is, while the PDF document is converted into another document like a Word, the security process, which was a password protection which was given to the PDF ebook, was getting removed when it is converted into the other formats. So therefore, if somebody downloads this software in USA and uses it to convert an Adobe PDF ebook, which is password protected for the purpose of copyright, into another format, it became a freely redistributable software. So it was breaking the copyright protection. There was a law in USA, even now it is there. It's called Digital Millennium Copyright Act. Now similar provisions are there in India also. Under the DMCA, any person who produces a tool for breaking the copyright is also guilty of DMCA and is liable under the Copyright Act. Act. Same thing is now there in India. So Adobe wanted to take action against this Elcom Soft, and particularly this person was a project leader. So what they did, they invited him, either they invited him or he took some invitation. He came to USA for addressing a hackers conference or whatever, something like that. And in that, his topic was security of ebook or something like that. He finished his lecture, and before he went out, the police were there to arrest him for the reason that now that he was in the jurisdiction of USA. So this person was arrested and tried in USA for about 6 months. He was in USA only. Subsequently, with a lot of government pressure from USSR and other things, and his undertaking that the intention of the software was not to break this particular copyright, etc., then he was left out. So that is how the rights management, if it is broken in any manner, could not only make the person breaking liable, but also his company and other managers of the company liable. Okay. So that answers your question. It is a combination of Copyright Act, but evidences and other things could be in the form of digital evidence. It may not come under directly ITA 2000, but it does come under Copyright Act. Okay. Then in which more crimes are seen? ICS, web applications. At this point of time, more on the web. but more damaging cyber crimes will happen in ICS. That is, if you're talking of industrial control systems, because there, if a batch, suppose you are a chemical plant and you are processing a batch, one batch, if it is spoiled, then perhaps you will be losing several crores of rupees. And we don't know, in some chemical plants, the misprocessing which can occur because of manipulation of the devices can make your boiler burst, make some poisonous gases come out into the open, and the liability can go to unlimited bounds. It is not one production loss, 1 day's production loss, or one batch production loss. It can be leading to the closure of the unit and permanent jailing for the owners of the company, like what perhaps happened in Vizag and other things that could be caused by hacking into a industrial system. Very recently in Bangalore, we had a threat to Wipro. One of the disgruntled employees sent an email saying that he will spread ricin. Ricin is a form of a poisonous element. He said, I will spread ricin in Wipro premises by using a drone. And I will also use it in Wipro canteens, etc. So he was actually threatening a mass destruction of Wipro premises because he was a disgruntled employee. So he could have executed it. It didn't happen, but he could have executed it. So such things could be much more damaging than a web application where somebody is perhaps doing something like creating some fake documents, downloading some pirated software. These all will go into insignificance when you look at the possibility of larger losses which can happen in the industrial control systems. But are there the same kind of information security practices in an ICS environment as compared to a Wipro or Infosys or a TCS? You and I know that the persons who are managing the ICS systems might not have heard of cybersecurity at all. Whereas a person who is handling some applications in the Infosys and Wipro, they are trained in cybersecurity. So the possibility of securing is better in these IT companies, whereas in these industrial companies where many of the mechanical engineers are going to join, there may be zero level of cybersecurity when it comes to ICS systems. There also security may be there in the computer systems, in the management division or something like that. People may forget to see that their whole production system will be managed by computers. In fact, we are going into industry 4.0 situation where the robots will be managing the whole platform. So there the risks are much higher. So we have come to 11:30 now, so it's open to you to tell me whether we can close the session.
I think, sir, the questions will be never ending, but we have to take a call, and maybe participants can pose the questions later. We can float a form wherein the participants can float questions, and then we can redirect the questions to you and get back with the answers. Will it be okay, sir?
That is fine.
Okay. Okay. So yeah. Sir, now I would like to invite our senior faculty member Nandana Prabhu Madam to give the vote of thanks.
Hello, sir. Thank you, Vijay Shankar, sir, for accepting our invitation and for this wonderful session. You have given a very good illustration from the technology perspective for various practical scenarios, and you have also given the corresponding act which is associated with it. You have given very good elaborations on the ITA 2000 Act and also the role of the educators and the police, and in the end the data evidence and the sections associated with it. I'm sure it was a very interactive, very good session, lively session, I'll say, which we can see from the question and answers session that we have had. It was really a great session, sir, in this scenario wherein we all are communicating mainly, whether it's personal, whether it's official communication, we are using the internet. And in this scenario, you have given your valuable time for taking this session. Thank you very much, sir. I also thank the coordinators of the department for organizing this particular session, and participants. Thank you for attending this session. I'm sure it was a very lively session for all of you. A great amount of information is obtained, particularly with cyber laws.
Thank
Thank
you.
you, sir.